The Public Works. It's good to see my colleague, Councilman Arcon, joining us. We have the Honorable Council Members Jose Bizarre and Councilman Krikorian. We're anticipating Councilman Englander, perhaps?
Pardon me?
Are we anticipating Councilman Englander? Yes, we are.
Anticipating.
Great. What I'd like to do is maybe just jump into Plum Committee really quick and do the continued items and those that are going to be referred. And that way folks that are here for those don't have to wait much longer. And then as soon as we get Mr. Englander here, we can jump to a Public Works Committee and Councilman Wisari can open up that meeting. But at this point, seeing no cards on, we do have a report from SCAG, and I know we have staff here, so we'll call that special. Number 2, I believe we could refer to the City Boundary Adjustment Board and request a status update in 45 days on number 2.
Yes, sir.
Okay. Seeing no cards on 2. We do have cards on 3. 4 special, that's with the Public Works Joint Committee. And 5, we can continue in Plum to October 25th, and hopefully in Council November 16th. That'd be number 5. I don't see the Director of Planning here today, so we don't anticipate a report. So that could take us, okay, so we go to item number 4. And Councilman Rizal, I'd like to do the honors opening up the Public Works Committee as a joint committee.
Thank you, Mr. Chair. And in the Public Works Committee, we have President Mr. Alarcon and myself as the chair. I believe we are expecting Mr. Englander shortly. And what's before us today is a long-awaited report back from the City Attorney's Office on the potential options for the city to regulate cell towers. It seems that for a long time, the industry has argued that cities do not have the right to regulate cell towers within their jurisdiction. Several recent cases, as presented to us from the City Attorney's Office, has shown otherwise. We heard this in Public Works Committee in June, and as soon as the new City Attorney, we heard this when the new City Attorney report was released. We had over 20 residents comment on the report and asked us to give an expeditious review in Council. At that time, I thought it would be best to have a joint Plum and Public Works Committee to review this issue, since it could be complicated, and we wanted to make sure that both committees are headed in the same direction before it gets to Council. So with that, I had asked Chair Reyes if we could have this joint committee, and I want to appreciate Chairman Reyes for agreeing to have this joint committee, and I want to thank his staff for moving so quickly to hear this item all at once. And believe me, sometimes it takes a while to get these items on committee calendars. And so with that, I'd like to ask, if you don't mind, the City Attorney to come up and present the report, unless, Mr. Chair, you want to do public comment first, or?
Well, I just wanted to make sure we allowed our colleagues, if they had any words, any comments, observations at this time. I just want to thank you for making sure this happened. And I can share with you, colleagues, about 8 years ago, when we were going through all these different permits and issues, we would have very, very long meetings on each case because of, one, the emotional factor and what these cell towers can do to our health, knowing there was FCC restrictions upon us at that time. But we didn't have the kinds of cases that are evolving now. So it's good to take a fresh look to see where discretion can lie and or how policy could evolve, but we don't feel so, this is rather graphic, but I feel like we're stripped naked to do absolutely nothing. We were just bare bones, just have to say yes and too bad, and I think that did not bode well with many of our constituents. So right now we're going to hopefully find some leveraging, some discretion that speaks to the FCC rules, but also a healthy society. And Councilman, any comments or observations on this?
Well, thank you, Mr. Chair. I'm going to have
I'm sure a lot of questions following the presentations today, but I think in every one of our districts we've had the experience of an especially troublesome installation project that has taken residents by surprise, that has been particularly offensive to residents, and it's been a frustration, I know, for all of us to feel that we have limited jurisdiction to be able to address that problem because of federal and state preemptive problems. So I appreciate that we, at long last, finally have the long-awaited city attorney analysis, and that will provide us with the beginning of an opportunity to start having a more comprehensive discussion about how we balance the needs of neighborhoods and communities with our interest in having a telecommunication system that works and serves our residents as well, and how to best do that in a way that protects the concerns of our citizens. And so I think this is going to be the beginning of that discussion. I hope it'll be a long and careful and thorough discussion that takes into account all of those important policy objectives that we have to meet.
Hey, Councilman Alarcon, any thoughts or comments, observations? Okay.
So why don't we at least, first begin with, is the city attorney's office here with the report? And let's just have a brief overview of your recent findings and in the report, what it says, and then we'll go to public comment and open it up for questions and comments from the committee.
Certainly. Ted Jordan, Public Works General Counsel. It's a bit odd to be on this side of the podium. Usually I'm sitting over there. Just to go through the report, I will give you an overview of what we have, and then obviously feel free to have any questions that you ask any questions. First of all, just for clarification, when we talk about cell towers, we're talking about more than just an antenna on a pole. For purposes of this discussion, I consider as a, quote, cell tower, unquote, a freestanding antenna pole. That is a pole that is not a utility pole. There's no transmission wires on it. It's a pole with an antenna on the top. I'm also looking at the utility cabinets. So when a company such as AT&T or Verizon want to roll out their new video franchise service and they need a cabinet on the ground, we're considering that as well. We do have many issues that come up with those. Also, we're talking about antennas that are mounted on utility poles. So your typical utility pole, maybe DWP owned, has transmission wires on it. It provides a convenient place to put an antenna, and antennas need to be up high. When we talk about what we regulate and what we don't regulate, what our current regulation is in the right-of-way is the above-ground facilities ordinance. The above-ground facilities ordinance regulates the structures that are installed in the right-of-way, except there currently is an exemption for antennas that are mounted on utility poles. So if a provider wants to have an antenna on a utility pole, they go through DWP typically, which owns many of the poles, and under their membership of the joint pole agreement, utility companies are allowed to share the use of those poles, and the antenna is installed on the utility pole. There's no permit that's obtained, and the first time the community knows about it is when they see it. Unlike anything that goes through the above-ground facilities ordinance, the cabinet or the monopole, there is an application. There is a notification to homes or residents in the neighborhood, property owners. There's a notification to the council office, to the neighborhood councils. If there's an objection made, there is a protest process. If it requires a variance because it's too tall, and that would include all of your pole-mounted facilities, then there's a variance, and the Board of Public Works decides that issue. Now, from time to time, people have been upset about the findings, and they've been upset about the structures mounted on utility poles, so we've taken a look at what we can do. There's case law has developed recently that gives the city some additional tools to regulate this area. One question that's been out there is whether we can regulate based on aesthetics. Well, recent case law shows us that it is possible to regulate based on aesthetics. We have regulations currently, but those are regulations that can be built upon. Another question that came up in the recent case law, which council asked us to take a look at, was the standard that the Ninth Circuit would apply in considering the laws such as the cities. Basically, recent case law from the Federal Court of Appeals in the Ninth Circuit has given cities a freer hand to regulate based on a whole host of features. The federal law that applies to the city basically holds that a city cannot prohibit service. So a regulation cannot have the effect of prohibiting service. What that means is that we cannot prevent a telephone company we cannot prevent them from closing significant gaps in their signal coverage. Federal law also prohibits local governments from regulating the location of cell phone towers based on their environmental effects. We talk about that from time to time and refer that to the health effects. Current state of federal law is you cannot regulate based on the location. You cannot regulate the location based on the health effects if the particular equipment is operating within FCC guidelines. So if you have an antenna that operates within FCC limits, the city or any local government cannot regulate the location based on its environmental effects. There's also state law that governs the city. State law is in the Public Utilities Code, and it gives telephone companies essentially a franchise to use the right-of-way for its equipment, subject to local government's ability to regulate the time, place, and manner of how they do that. And that's where issues of aesthetics come into play. We've taken a look at the recent case law and also what some of the local cities around us have done, and we've identified a number of additional mechanisms or tools available to the city. As I said before, we currently do not regulate what goes on the utility poles because we have an exemption in the AGF ordinance. One possibility for the council to do is to remove that exemption. So if a company wants to install an antenna or a box on a utility pole, they have to go through the AGF process, where there's a permit, there's a notification to the public, there's an opportunity to challenge that, and there's a decision made by the Board of Public Works in an open meeting. Another tool we think is available to the council is to increase the regulation that we have based on aesthetics. Right now we have some requirements. The poles need to line up in the right-of-way. We look at whether or not it's blocking streetscape views. We require sort of color and landscaping considerations. Well, there's more that we could do. We could look at the areas and say these requirements would apply to commercial areas, these requirements would apply to residential districts, and so on. Another issue that comes up from time to time is who should get notification of a AGF application. Right now, the current ordinance requires notification to the adjacent property owners. There is no sort of radius of notification. Now, the council office is also notified and the neighborhood councils are notified, but surrounding property owners that don't happen to be immediately adjacent to the site, they don't get a notification. Well, what we've taken a look at is when the planning department is considering a conditional use permit for a site like this, when it's not in the right-of-way, they have a 500 feet notification radius. So one of the possibilities that we could have is to expand the radius of notification so that it matches what would apply to a conditional use permit. So if its antenna is going to be installed in the right-of-way, it gets the same notification as if that antenna is mounted on the rooftop of a building. Another issue that's come up with some of the cities surrounding Los Angeles, in their regulations, they've put in time limits. So when a permit is issued for a cell phone site, it's good for, say, 5 years or 10 years. Our current ordinance doesn't have a time limit. So once you get that permit, you have it. So another tool that would be available to the city council would be to have the permits be limited to a certain amount of time. Lastly, when I talked about the federal law and I talked about how you cannot prevent a company from closing a significant gap, well, the analysis for what is a significant gap it's complex. We've dealt with that from a legal standpoint from time to time, but what a cell phone company will tell you is they need to have that site there because they don't have a very good signal. But whether that's a significant gap or not is a different issue. It's a legal question. So what some of the cities around Los Angeles have done is they've required the provider to provide more information about why they need that site, what other alternative sites are available, and if necessary, they have to pay to have an expert consultant come in and provide that information so that the city can make an informed decision as to whether or not that's a significant gap. Anecdotally, what I've heard is if you go to a website for any of the cell phone companies and you pick an area, do I have a good signal there? The website might show you a very good signal because they're trying to sell you service. But when they come in with a permit application to get a cell phone tower, you get an entirely different map. So if we're going to look at significant gap, that could be built into the application process. And if you have any other questions, I'd be happy to try to answer them for you.
In terms of notification, how is it being proposed to strengthen that level of communication? There's a motion I forwarded how long ago was that, Roberto?
May 2007.
In 2007, I had pushed for making sure everyone gets notified, not just the property owner, but the tenants and or the occupants within 500 feet of these facilities, given that just a little over 60% of the folks living in Los Angeles are renting. Our ability to communicate with our constituents is important. So does ordinance take into account the motion that was passed a couple of years ago?
That's a good question. For the record, the council file on it was 10-0664. I have a copy of your motion in front of me. The current ordinance doesn't reflect this. That would be one of the tools that we'd have available to us that we've described in our report, which would be to increase the notification. And while we're talking about notification, there's actually two issues, one of which has been resolved administratively by the Bureau of Engineering. The other would be addressed by your motion. And when I say there's two issues, I talk about there's the radius of notification. We can expand that along the lines of what you have here, and we would have to tailor it in such a way that it applies to both property owners and residents. The other issue is what's in the notification. Now, currently, because certain elements are exempt from the ordinance, for example, an antenna on a utility pole, for that installation, there may be a cabinet that goes on the ground right next to the utility pole. Oftentimes, there's a requirement for a cabinet that deals with the power meter. So when they send out the notification for the AGF application, all they're really doing is applying for a permit for the cabinet. And so that notification might not show the utility pole with the antenna on it because that is currently exempt. So administratively, the Bureau of Engineering now does require applicants to include not only the very thing that they're trying to get the permit for, but any other structure associated with that, so that the public, when they get that notification, can make a more meaningful and informed decision as to whether or not they want to challenge that. It's one thing to have a cabinet on the ground, it's another thing to have a cabinet and the antenna. So we've dealt with that administratively. We could build that into the ordinance. In terms of the 500-foot radius, what we could do is take a look at what the planning department does for its conditional use permits, and if that model has proven to be successful, then we can simply use that same language. The key is, though, in my opinion, the difficulty would be is to get the multifamily units. In an apartment building, you don't necessarily have easy access to put a door hanger on the door. So there would have to be a way to ensure notification of the individual apartments. Now that burden would be on the applicant, and so we could build it into their permit application process. And it would have to involve probably contacting managers of apartment buildings or that kind of thing, or knowing how many apartments are in that building and then literally mailing out a notification. But what we could do at the beginning is take a look at what the planning department has done, and if that has worked, then just use that same model.
I think the term occupant perhaps alleviates some of the pushback that can be basically creating reasons not to notify us. We don't know who lives there, we don't know what their address is or their name. We can use the term occupant, then we can cover all the different units that are being impacted, and that'll help hopefully facilitate the awareness of the local neighborhoods who would be impacted by these types of facilities.
Yes. Another option that would be available that would work in some locations but not others is having something physically posted at the site where you're going to have that installation. Now, if you're talking about an antenna that's going to be mounted onto an existing pole, whether that pole is a street light or a utility pole or some other kind of pole you're going to co-locate on, you could physically post something at that location that would put residents or passers-by on notice that that's going to be installed there. That model would be less practical for locations where there isn't currently either a cabinet or a pole, because then there really isn't anything to affix that notification to.
Thank you, sir. Any other questions? No. Sir.
Yeah, if I could just follow up on that one point, because I think that's actually a helpful suggestion. The current ordinance that we have requires a certified mail notification, and so there are times when somebody might not pick that up. They might not receive actual notification because of that. They get something in the mail, don't know what it is. They don't go to the post office and pick it up, which actually, in fact, happened with a project in my district. Mm-hmm. And posting at the site would have the potential to avoid all of those problems of literal compliance, but lack of actual notification of the neighborhood. And I'm wondering if there are there models like that you've seen in some of these other city ordinances or any other city where you're aware of that would have a physical posting requirement? That's part one. Part two is, can you talk about some examples of other more useful content that might be contained in the notification, other than, sort of the legalese description of a facility that's going to go up, something that actually has perhaps a website that people can go to that will have a description of the project and photographic illustrations of the project and that kind of thing. Have you seen that in other ordinances?
Part one, I'm not aware that the other cities that have legislated in this area have, if they've had that sort of posting requirement, but I think it's a good idea. So it clearly wouldn't be in lieu of the notification. I think, all attempts to notify people should be made, both by mail and otherwise. In terms of what should be in the notification, obviously people need to know what the site is all about, but I think another issue that they would need to be informed of is to who they should contact if they have further questions about it, and that could be the applicant. That would then be able to make information available. The notification could include better photographs, renderings of what the site looks like. With today's computer technology, it is very simple to show a photographic simulation of what the site will look like. To the extent that the notification is made, it really should have, all information necessary, or at least a way for a resident to get that information so they can know exactly what that site is. Another thing that a notification should include, ideally, would be who to talk to if you're opposed to that site, and what the process would be, whether that is filing an appeal with the Bureau of Engineering, or contact information for the Bureau of Engineering. They're currently the group that handles these kinds of permits, or any other group that would be involved,
and
including the council office.
Not just if you were in opposition to it, but also if you had ongoing concerns, for example, about the actual process of the construction and, issues like that, again, I hate to focus this continually on circumstances that happened in my district, but there was a project where the neighborhood had significant concerns about how the construction itself of the installation of the underground vault was handled.
Yes.
And there was no contractor information, there was no building and safety information, there was nothing, no vehicle by which they could pick up a phone and call somebody and say, this is creating a dangerous condition, for example. So if that sort of information could also be included in the notice, and especially posted at the site, I think it would give people a lot more of an opportunity to have realistic input.
Correct. I think there would need to be a balance between how much information is on a notice, because a notice has to be, something that people are actually going to be able to read and understand. And if we put too much information on this thing, people
a single phone number.
Yeah,
a phone number with somebody who can answer questions.
So there should be a way to there should be enough information for you to know whether or not you're going to have an issue with this, and then also a way to contact anybody, including the construction issues, because many of the sites that are built in the right-of-way include some underground construction. In some cases, there are vaults that are quite large. You're talking, the size of a car. And so there's going to be a substantial excavation, and that project will include that construction, and there's going to be impacts on traffic and parking and other things. So all of that should be part of an ideal notification. And what we can do is take a look at what some of the surrounding cities have done. Unfortunately, we're a little bit behind what some of the other cities have done. But on the other hand, that gives us a chance to take a look at what, thoughtful councils have done, and we can take sort of the best of the best. I would be remiss in not noting that, at least in one case, the city has been challenged. The city of San Francisco, city and county of San Francisco, has a new regulatory law in place, and there's currently a lawsuit that's been filed. So we're taking a look at that. It's still in the pleading stages, so we're not really sure whether that's going to go anywhere or not. But we can at least take a look at what's been happening. And one other point, and I would be remiss in not saying this, what we're talking about is imposing a lot of additional regulation in some things that are not currently regulated. And there are a lot of installations that are being proposed currently, and there will continue to be a lot. To the extent that we're going to be incurring additional staff time, there's a resource issue, in which case the Bureau of Engineering, it's a substantial amount of resources that would be involved in their review of these applications. So any additional application requirements or broadening of the scope should also probably include the fees necessary to support the staff that would be then reviewing those applications. But the department can, at a future time, address those staffing issues.
I have one other question before we go to public comment, and that is on the current exemption for existing poles. Now, it seems to me that well, first of all, did you look into what the sort of legislative history was, or what the policy rationale was for that exemption in the first place? Because as I understand it, it's not required by the Joint Pole Authority nor by state or federal law to provide an exemption for existing poles in the right-of-way. Is that right? It's a policy choice.
That is correct. We've worked with, we've talked to DWP. Part of this process, we've worked with DWP, and we've talked to them about that, just to make sure that we're not recommending or giving you an option that would then somehow be contrary to either their legal or contractual obligations under the Joint Pole Agreement. The Joint Pole Agreement does not preclude, and in fact it recognizes that the use of the poles is subject to local regulation. As to why the exemption was made in the first place, I have read through the legislative history of the existing ordinance, and I don't get a clear reason as to why it was exempted.
Okay, so this is one of many areas involved in this issue where I think we need to, do a fair amount of homework in drawing stakeholder input, because I could see adverse policy ramifications coming on both sides of this question. If you have an exemption, then you have fewer poles in neighborhoods, because there's an incentive for installation on existing poles, where if you took that exemption away, you'd have cell phone companies installing new poles, and so you'd have a lot more poles in a neighborhood. On the other hand, if you get rid of the exemption, then you would have the protection of the aesthetic regulations and so on under the current AGFSP, or an expanded, more robust AGFSP. So you can see negative impacts to neighborhoods with either choice, and I think it's going to be important as we make those choices to have the input of both communities and the industry as to what the ramifications of that choice will be on quality of life in neighborhoods.
Yeah, if I may comment, certainly that's correct. There could be unintended consequences. I think given a choice between having one pole in your neighborhood and having two poles, most people would choose one pole. Although I challenge the requirement that there has to be a pole, because there may be another location that won't require that if there's a suitable site on private property. But certainly co-location, so you minimize the number of physical poles, I think would be a good goal. Another area that's come up in this is the technology is developing. The antennas and the equipment necessary is getting smaller. We've seen articles, although I don't know how many years away it is, that depict very, very small antennas. These things could be done in a way that they're I don't want to say invisible, but they would be much less obtrusive. Currently, the companies have also worked with a thing called a stealth pole. So if you imagine a pole that has a crossbar with stuff hanging on it, you can contrast that with the stealth pole, which is simply a metal pole that has nothing hanging off of it. All of the equipment is physically inside the pole. And in some areas, to blend in with the natural and other surroundings, that metal pole can be wrapped with a sheath that simulates, in my opinion, it looks pretty good, a wood coating. So when you look at it, it looks like a wooden pole. Now, there's nothing hanging off of it. Again, is that better than the utility pole with the things hanging off it? Probably. Is there another location that wouldn't be in the right-of-way where that antenna could be located? That could be part of the application process to have the provider demonstrate that there are no other locations, whether they can either co-locate or have it, off of the right-of-way.
Mr. Alarcon?
This? Okay. I couldn't imagine that anybody, a utility pole is already an eyesore. It's like almost part of the definition of a utility pole. Nobody wants one. They're ugly. So to the extent possible, undergrounding the wiring of Los Angeles is a preferred alternative, which would cause further dilemmas with regard to cell phone usage and access issues. I'm concerned about that because I have a major project in my district where I want to eliminate all the utility poles, and yet I don't know how that would affect cell phone service. But really, what I want to hone in on for purposes of this discussion is page 2 of the city attorney's report, where it says federal law. It's A1 on page 2. Mm-hmm. And it says the Federal Telecommunication Act of 1996 prohibits municipalities from creating regulations that ban or effectively prohibit personal wireless telecommunication services. Local governments retain some authority to regulate telecommunications installations, provided that such regulation does not have the effect of prohibiting service. Whether a municipal regulation effectively prohibits wireless telecommunication service is a factual determination that hinges on whether the city has prevented a wireless provider from closing a significant gap in service coverage. Moreover, under the federal law, a city's decision to deny a request from a federal wire service provider to place, construct, or modify its facilities must be supported by substantial evidence. And lastly, the federal law does not permit municipal regulation of wireless communication facilities on the basis of environmental effects of radio frequency emissions. The several letters that I've read of complaint actually specifically target radio frequency emissions as one of the reasons they want us to approve the city attorney's opinion. But under federal law, it would be essentially illegal for us to do so on that basis alone.
Yes, that's correct.
Or on that basis whatsoever.
Well, provided that the structure that you're regulating operates within FCC limitations. There are limits that the FCC imposes on this type of equipment. If a piece of equipment were found to be operating outside those limits or those guidelines, then the city could essentially deny the permit.
Okay, so
if you're operating within the FCC limits, then your reason to essentially deny a permit would have to be based on something other than the environmental effects of the emissions from that device.
I'd just like to set that aside because I just want to make sure whatever we do it because of that, because that would undermine whatever we do. It could be a poison pill if we move forward with the city attorney's recommendations, if we do it on the basis of our concerns for radio frequency emissions. Secondly, the definition of prevented, where it's used, prevented a wireless service from closing it, and also the term significant gap, those are tricky terms. They're very ambiguous, and they're subject to definition. Where would we find the definitions for those terms?
Case law. They're not,
Okay, so how, as a council, how do we make that determination? It seems to me that we have to have definitions that are consistent with the case law in order to have a sound case, and how do I say this? To reduce the risk of legal challenge.
you're right. These are very difficult issues. It's a highly factual determination that is going to depend upon the given situation at a location. If there were litigation about whether or not we were preventing the closure of a significant gap, ultimately there would be experts that would have to come in to testify.
Right.
Each side would have an expert. One would say there's a significant gap. One would say that there's not a significant gap.
So if we essentially said, okay, the underlying assumption here is that by not allowing a cell tower to exist in a particular location, we are essentially at the same time denying access to cell phone usage to theoretically some group out there.
That's correct.
Okay,
or
so
they would be less than ideal.
So
signal.
ideally, we are basing our decision regarding, it's a decision about access versus public safety, or in this case, or in the case of those, the arguments of most of the opponents, aesthetical concerns.
Yes, and there's
Okay,
a balance.
So if we deny on purely aesthetical basis, is that the strongest argument to deny?
Well, first of all, you need to have an ordinance that.
I mean, so for example, there's a utility pole, the thing's already ugly, and you claim that you want to deny it because it's uglier, or it's not in conformance with the community. When I would argue that every utility pole is not in conformance with the aesthetics of a community.
Yes.
So it would seem to me that would be a very weak argument to hang your legal hat on.
If you had an ordinance that established the criteria or the aesthetic requirements, and a proposed new site failed to meet those criteria, then that would be, a court would likely find that is the substantial evidence necessary to deny the site.
Okay, I'm sorry, could you say that again?
If you have built into your ordinance aesthetic criteria.
No, but what I'm saying is a utility pole is ugly by nature. It doesn't aesthetically add much to a community. I don't know anybody who would argue that it does. But so you put this thing on it. To me, it would make it very difficult to argue that aesthetically it's inconsistent when you already have the ugly telephone pole.
Well, what a typical ordinance would have is aesthetic criteria, and the argument could be that the additional structure necessary to support that antenna, because on utility poles, because of some clearance requirements, there's frequently crossbars that stick off the pole and then the antennas hang down, that additional structure would be what you'd be, from an aesthetic standpoint, be denying. An ordinance could also require that.
I understand that, but my original question was, given that the utility pole is already an ugly thing, that seems to be a weak argument.
I hear what you're saying.
I think that
could be
what other considerations are we required? This paragraph implies to me that there are other things that we need to be considering to strengthen our arguments.
If a provider is part of an ordinance, is required to show that they have exhausted all of the other locations that could be possible, and they have failed to do that, then that could also be an independent basis for denying the application.
Okay. If you could, I think one of the strongest arguments would be, well, there's plenty of access. Nobody's losing their phone calls.
Well, the access, actually, you raise the issue of access or the signal strength. there's actually a couple of issues there. One is, from an objective standpoint, you could have an expert come in and do a survey to show the signal strength in the area. So as an objective standpoint, you can know this is what signal is there and this is what signal is not there. You could see on a map who's covered and who isn't. But then the other issue could be what kind of signal do you want? Do you want to have the lowest possible signal so that the phone works, or do you want to have a 3G or 4G signal so that the people can stream a movie on their phone? And those are all issues that would come into play in this issue of what is a significant gap.
I guess my concern about the report is that it is focused on aesthetics, and to me, particularly with regard to utility poles. I mean, you're talking about building one of those phony trees out there that don't fit in. I mean, that I have no problem with that. Those, you know, in some neighborhoods, I guess it might enhance, but in most neighborhoods, they look odd. But when you're talking about utility poles, I'm concerned that we could get the impression that just because we don't like the way it looks, we can knock it out. And I'm thinking that's a very weak argument, that the report, since it's focused on that, it doesn't really paint the true picture of all the other considerations that we have to make. For example, economic implications. If we're boxing out a particular commercial corridor by not having access to this, and businesses are not able to get their signal, and they start screaming that they're not able to do business like the other neighborhood can. And so I'm just wondering, I don't want to create a false impression that by passing the city attorney's recommendations, it's a slam dunk to stop a cell phone tower, because I don't think that's going to be the case. I think what's going to happen is you're going to get public safety people coming in complaining about public safety issues. You're going to get different economic classes of citizens complaining about not having access when other communities do, business concerns, economic concerns, unions complaining about job loss, all of these factors. And when we make a decision, we can't just consider the aesthetics. We have to consider all of these things. So I was hoping to get a clearer picture of all of those considerations that have to be brought to bear when we're making a decision about these things.
Councilman, if I may, one of the, going to put this, the historic kind of implementation of how we address the notion of where they go. What I find right now in the language that's in front of us that we need to continue discussing is that the FCC cornered off many of the more pragmatic concerns, the more practical issues, because of the way FCC was interpreting this law. And so what I find in this body of work is an effort to carve out niches that gives us discretion, as odd as it does sound. You know, we're worried about aesthetics, and you're right, the pole is really ugly. I mean, are we going to start calling it uglier? I mean, you know.
I think, yeah, I'm older than all you guys, but even though you were around, Ed, when we had this discussion the first go-round in the 90s, you know, politicians wanted to have control of this issue so they could raise more money. You know, and the jurors, so that when the state legislators were trying to take it from the local legislators, and the Fed officials were trying to take it from the state officials as a money-raising scheme. That's, you know, that's the facts. And so the question to me is, it's not an easy decision, because when I remember when these cell towers were being built in the first go-around, and I always remember there's one tree that was built in the middle of a corral in my district, and it just didn't make any sense at all. But ultimately, the policymakers, whether they be local, state, or federal, they approve them. So we give the appearance of blocking the cell towers, but at every level, they've always approved them. And the only thing that was different was who received the campaign contributions. So I just want the public to understand that the control that you seek, it has to be monitored very carefully, I don't know that there's going to be substantive change at the local level, even if we change and make this a reality. That wasn't a question.
No, no,
I don't think
I
you should
agree
answer.
that-
I don't think you should answer.
Let me get a public comment, but I think what the city attorney's office did is, given recent case law, and they saw an opening for us here locally to make changes. A lot of it still remains closed for us to review at the state and federal level, but at least, do you feel comfortable that you've presented to us recommendations as to what you see are openings for us to update our law in this area?
Yes,
Our
I do.
ordinance? Yeah,
Yes,
okay.
yes, I do. And because the one local ordinance, the one in San Francisco, has been challenged, we'll be continuing to monitor that. It's, again, in the pleading stage, so there hasn't been any new law generated from that. In the past, the cases that we've actually looked at and discussed in the report were also the results of legislative action. And so based on that, we have a better understanding as to what we can do. This San Francisco case may present further issues, but when we looked at this issue several years ago, and I personally advised the Public Works Committee, well, we should hold off. There's some cases out there. Those were these cases, and these cases have now been decided, so we feel comfortable that, we can go forward. In the end, though, the decision to whether or not a particular site should be approved, those are not easy decisions.
Yeah, but I think Mr. Alarcon's point is well taken. That is, that although the public may expect us to change certain parts or to conduct ourselves differently, we're still working within the confines of state and federal law, and we're just looking at a little opening that was given to us so that we make those adjustments and update our laws currently. And so, although even in Public Works Committee, I've heard a lot of issues raised by the public that, it's still a state or federal issue and guided by them and regulated by them. So we've got to be clear, I think, as to what is it we can and cannot regulate at this time, given the new case law. And we'll get through this process as it continues, I think. We'll go to public comment now. And
Councilmember, if I just interject, I just want to make a quick announcement. Item 3 has been continued for 2 weeks. Item 3, thank you.
Item 3 continued 2 weeks. Okay. Our first public speaker is Yukiko Kato. After Yukiko Kato is Ken Kato. Yeah, would you wish to speak? No? Okay. All right. Our next speaker is Barbara Kahn. Barbara, are you here? No? Oh, yes. After Barbara is Christina Spitz.
Good afternoon. My name is Barbara Cohn, K-O-H-N. I'm president of Pacific Palisades Residents Association, a 50-year community-wide organization, and I'm a member of the Los Angeles working group that's been dealing with the cell tower issue for the last 2.5, maybe going on 3 years. We definitely support the city attorney's report. It's critical that something be done in the city of Los Angeles, as has been done in other jurisdictions, including Glendale, currently Burbank, of course, San Francisco. And whether the polls are ugly or uglier is immaterial as far as I'm concerned. Something needs to be done to regulate what is going on in the public right-of-way in the city of Los Angeles. Thank you very much.
Thank you. Christina Spitz. After Christina Spitz is Alexander von Weckmar.
Good afternoon, Honorable Council Member. I'm Christina Spitz. For ID purposes, I'm Chair of the Land Use Committee of Pacific Palisades Community Council. I'm Vice President of Pacific Palisades Residents Association. I'm an attorney on inactive status. I'm also a founding member of the Los Angeles WTF, which stands for Wireless Telecommunications Facilities working group, which is made up of several community people who are here, some of them who are here today. My remarks today are on behalf of the working group. We've been working with the city attorney on this issue, and I personally have been working on this issue for more than 2 years. We commend the city attorney. We think the report is excellent. We fully support his recommendations. There are a few other things we'd like to see, but I don't want to waste the council's time. I know there's going to be more discussions. But one thing I do want to address, I want to deviate slightly from my prepared remarks. Councilman Alarcon raised some important points, and I do want to make these points so everyone understands. In terms of utility poles, the utility poles typically, from my experience, and I've observed some of them go up, are short utility pole, what's called a support pole in some parlance. They don't have anything on it, so it isn't the ugly thing with the crossbars and everything that's already ugly that Councilman Alarcon was referring to, which we all agree are ugly. Often, and in most cases, they are short support poles that people hardly notice, and there are some people here in the audience who've experienced this in front of their homes. Then, and this is an example of one, what will happen is the cell company will come in, and this is all exempt, and install a much taller, in some cases twice as tall pole with a lot of equipment on it that's ugly. Here's another example, Palisades. This is a prior pole about that high. Now you have this thing looming next to a home without regulation. That's the point. We want to see some appropriate regulation, at least if there are aesthetic guidelines, then we can maybe get more in the way of the stealth poles and that kind of thing. Or, if appropriate, discourage them from being installed right next to a home. We want to see better cell regulation. Everyone does. We're reasonable. We would like to see appropriate regulations. Thank you so much. We also are asking for a temporary moratorium, which is something that many cities have asked for. We very much appreciate it. Thank you.
Okay, thank you. Alexander von Weckmar. After Alexander is Doug Arsenault.
Yes, my name is Alexander von Wechmar. I'm a board member of the Oaks Homeowners Association, which is an association of close to 800 homeowners in the Los Feliz area of the Hollywood Hills. And we welcome and support very much the report of the city attorney in regards to this issue. Before I want to make a proposal or bring your attention to an idea that I think we should look at, is in terms of the aesthetics that you were talking about. Imagine you buy a home in my neighborhood with a view of the Hollywood sign. You pay a lot of money for that view. And then one day a company comes and puts this thing in front of you, ruins your view for good, and you can not do anything about it. You have no say, and the guys don't even require a permit. Now this one at least needed a permit for a little cabinet that they put right next to this pole. But for the pole itself and the antenna, no. And the cabinet was placed there without telling the people even the purpose of this cabinet. So if they had known that this was going to be a 50-foot pole with these beautiful things hanging on top, I think you would have seen much more complaints about it. But what I wanted to bring to your attention is the idea, considering the city's urgent need for new income, we think we should encourage you to explore ways in which the city can generate additional revenue by charging cell phone carriers an increased fee or a fee, because right now I think all they pay is for power that they need from DWP, for allowing them to access the public right-of-way or the use of space of existing city-owned utility poles. Please find more details about this idea in our written statement filed back in November 18th of 2009. No one knows at this time how much revenue the LADWP receives from cell phone companies operating in the city of Los Angeles, or how much is lost to the Southern California Joint Pole Committee, a non-government agency that you may not have heard about, but which is often misleadingly referred to as the Joint Pole Authority.
Sir, your time is up, and we got to be fair to everybody, so we want to keep it consistent.
Okay.
2 minutes.
You find it in writing in front of you.
Yeah.
Thank you very much.
Thank you, Chair. Doug Arsenault. After Doug is Anita Gabrielian.
Good afternoon, council members. My name is Doug Arsenault of the Valley Industry and Commerce Association. VICA represents over 360 businesses in the city of Los Angeles and surrounding communities that have created 100,000 jobs. We understand the concerns of the communities, particularly ours of Studio City and Granada Hills. However, VICA recognizes that cellular service coverage is critical for all residents and all businesses of Los Angeles and for a functioning city government. The unprecedented and explosive growth of wireless broadband usage in the past few years, 8,000 in the last 3 years alone, requires increased bandwidth for personal and business communication, as well as emergency response, 911. More coverage means more tower construction. And currently, wireless service providers are doing so in a responsible manner that's in accordance with the AGF ordinance. They engage the community, they engage the council while proposing wireless locations, as well as meet with homeowner associations, neighborhood councils, and individual property owners. AT&T, for instance, has moved several proposed wireless sites purely to accommodate property owners. The AGF ordinance may not be perfect, but it works. However, if revisions to the ordinance must be made, we encourage the formation of a study group comprised of the CLA, the CAO, the city attorney, and the pertinent departments, LADWP, LAPD, LAFD, DOT. This study group could solicit input from stakeholders, including residents, businesses, community groups such as VICA, and the wireless industry in a structured and periodic manner. The group can then form thoughtful, objective recommendations for changes to the AGF, if necessary. We encourage you to be considerate in your determinations and move forward in a manner that will be best for both residential and business communities, including the concerned citizens that are here today and the wireless industry. We're all Angelinos. Thank you.
Thank you. Anita Gabrielian. After Anita is Kevin Tamaki.
Thank you. Mr. Chairman Reyes, Huizar, and members of the committee, my name is Anita Gabrielian, Regional Vice President of AT&T External Affairs. Thank you for the opportunity to talk about the wireless industry as you consider how to improve policies that make it better for everyone. Today, the demand for wireless services in Los Angeles and throughout the country has reached an all-time high. People increasingly rely on wireless telecommunications for personal, business, and public safety reasons, among numerous other reasons such as education, telemedicine, etc. To put this into perspective, AT&T has seen the mobile data traffic over our network grow by 8,000% in the past 4 years since the introduction of the iPhone. And by 2015, it is projected to be 8 to 10 times greater than that as more people are streaming video and using other more sophisticated applications on their devices. Additionally, more customers are exclusively on wireless devices. Currently, roughly 1 in 4 homes have switched to wireless only. And every month in the United States, 700,000 additional wireline customers cut the cord, or I should say the line. Reliable wireless infrastructure is needed to serve this growing population. These phones and other wireless devices, such as the iPad, need to ride on a wireless network. At AT&T, our network team is working daily to upgrade and provide the capacity that is demanded by our customers. We are investing heavily in bringing optimal wireless services to our city. Nationally, we spent we're going to spend close to $20 billion this year. Last year, we spent $19 billion. Here in the LA area, we've invested $450 million from 2008 to 2010. As we have expressed before, we look forward to working with the City of Los Angeles, and may I just say that an effective vehicle in developing this policy may be to form a working group composed of the most relevant city departments, a working group that seeks expert opinions, stakeholder opinions, and we look forward to being a part of that process and of the solution.
Thank you. Kevin Tamaki. After Kevin Tamaki is Kathleen Hill.
Good afternoon, members of the Joint Committee. My name is Kevin Tamaki. I'm with AT&T, and I just wanted to echo what Ms. Gabrielian said in terms of AT&T, and that we really pride ourselves a lot on being able to engage ourselves with communities, to work with various groups in terms of our planning process for placing wireless facilities. And we think that in a lot of ways it's the effective way to do it because it's a win for everybody. And we look forward to being a part of the discussion in terms of how the policy is looked at and going forward. AT&T does take seriously the design and placement of our wireless facilities. That's why we do engage with the various stakeholders, including community groups, homeowners associations, council, individual property owners, neighborhood councils. And basically to do that, we do that so that the public is aware, and that's what I do. My name is on the letter that goes out to the affected property owners, neighborhood councils, council offices, and homeowners groups, if appropriate, for our UVerse build. The current City of LA above-ground facilities ordinance has worked well because there is an appeal process with the Board of Public Works. In fact, there have been some instances where there were concerns from property owners for a wireless facility in the public right-of-way. We worked with the Board of Public Works, with the property owners, and we did make adjustments to the location of those facilities. But given the great interest in the placement of wireless facilities and the need for cities to keep up with the state of the art, we suggest that the committee take in input in a thoughtful, take its time and do so in a thoughtful manner. And the best way to do that is to form a working group and to get the input from all stakeholders. This working group would be comprised of the CLA, CAO, City Attorney, and representatives from various departments. So we look forward to providing input to such a group. We think it would be very valuable, and thank you very much for your time.
Kathleen Hill. After Kathleen Hill is Atana Cabanas.
Good afternoon. My name is Kathleen Hill, and I'm here on behalf of the California Wireless Association. The California Wireless Association is a nonprofit professional organization comprised of volunteers in all sectors of the wireless industry. Our primary mission is to raise awareness of the benefits of emerging wireless technology and to cultivate and nurture working relationships within the industry and between the industry, the public, our community leaders, and our political leaders. I just submitted a letter for the record that outlines our response to the city attorney's report, and at this time we would ask that you not implement the city's attorney's report until having a chance to meet with all the stakeholders like other speakers have said. We urge you to work with us so that we can all analyze the ramifications of what any changes to this ordinance could mean to not only the wireless industry, but to businesses and the community that rely on wireless services, emergency service providers, other users of the right-of-way, and also to analyze staff resources on having to do additional work and additional notification. Again, CAWA is based here in Southern California, and we have many members that come before the Planning Commission and city staff on a daily basis dealing with these wireless facilities. And we urge you to continue to work with us, and we would love to interact with the community and see if we can all come to a win-win solution. Thank you.
Thank you. Natana Cabanas.
Hi, my name is Natana Cabanas, and I'm speaking representing Get the Sellout. As Paul Krikorian knows, we are a Sherman Oaks neighborhood committee who was adversely affected by poor notification and poor installation procedures under the current ordinance. So we are not arguing that cell tower the use of cell phones are useful. We, in fact, recognize that. We would like more say and more notification in the installation of the cell towers. We do strongly support the city attorney's recommendations, but what is not in the report but was mentioned by Mr. Jordan was the option of permit durations. According to our current permits, there is no duration, and so we'd like to impose permit duration limits, and we'd also like to require that renewed permits fall under the requirements of the new ordinance, and that any pending permits would actually fall under the new ordinance laws. So thank you so much.
Thank you. Jack Allen. After Jack Allen is Nancy Friedman.
Good afternoon, committee members. I'm Jack Allen. As a retired city attorney who has specialized for the last 20 years in telecommunications law and been a consultant to 15 cities on this issue, I think I have an answer for you that will solve your problem immediately. You don't have to amend any ordinances. You don't have to adopt any new ordinances because you already have an ordinance that applies to every wireless telecommunication facility in the city, no matter where it's located. That ordinance was adopted in 2010. That ordinance is, let me get it out here. Ordinance number 1774132, and that ordinance, which I helped Cindy Miskowski draft, that applies to all. Here's what it says in it. Wireless telecommunications facility standards. Notwithstanding any provision of this code to the contrary, the following standards shall apply to the placement of all wireless telecommunications facilities. Doesn't matter what the AGF ordinance says because this supersedes that. But that's not the issue. The AGF ordinance itself complements this ordinance. It's another ordinance that I worked on. And it says right in it, pole-mounted and street-light-mounted facilities, street-light poles, utility poles, traffic and pedestrian control fixtures are not subject to the AGF-SB, but will be subject to all other appropriate requirements of law, which is applicable to the wireless telecommunications ordinance. The problem with the AGF ordinance is that the city staff is not enforcing the ordinance in the public rights of way. Why not? Because there's a myth. The city charter gives the Department of Public Works exclusive jurisdiction over the public rights.
Mr. Allen, if you could wrap it up, please. Your 2 minutes are up.
This is not true. Nothing in the city charter prevents that. What you should do is get the Director of Planning, the Director of Building and Safety, the Director of Public Works, get them in here with the city attorney and find out why they're not enforcing it.
We will look into that. Thank you, Mr. Allen.
That's it. I've given you a copy of a letter here. I suggest that you peruse it, please.
Thank you. Nancy Friedman. After Nancy Friedman is Barbara Broidy.
Good afternoon, council members. My name is Nancy Friedman. I'm the chairman of the Brentwood Community Council, and I thank you for having me here today. The Brentwood Community Council has been following the wireless telecommunications facility issue for several years, and in 2009 passed a motion to communicate with the City Council and other elected officials that the time had come to update the city ordinance regulating the installation of these facilities. Actually now the city attorney has done the report, and we are asking for the City Council and Mayor to enact a new ordinance consistent with the City Attorney's recommendation. And more importantly, since nobody's sitting here except one of you, I would like to say that we would like you to put a moratorium on this. If you plan on having committees or discussion, a moratorium would be asked by our neighborhood. People are irate. These things are going in the middle of the night. They don't know about it. They don't understand. They need to be educated, and a moratorium would help that. Thank you very much.
Thank you. Barbara Broidy. After Barbara is Edward McClaw.
Thank you, Chairman. My name is Barbara Brady. I represent Westwood South of Santa Monica Boulevard homeowners. I'm also a member of the West Side Neighborhood Council. Those of us here today are not challenging the cellular industry nor the future installations in this city. that's bunk, and it's also rather insulting. What we're here to do is to discuss how LA can institute regulations that take hold of this rapidly advancing technological creature. We have a tail that's wagging the dog in Los Angeles, much as we had with marijuana dispensaries and billboards. We have to take action. If the city wants to create study groups and study this to death, short or long term, then we need an immediate moratorium, because as we've heard today, our permits are issued without any expiration date, and we may be inspiring a rash of applications that the city will have to consider and be stuck with no policies, no findings, no criterias for evaluation. Over 50 organizations citywide have asked for reform of regulations. They can't be here today, but we're here on their behalf. 15 cities throughout California have adopted more extensive regulations than Los Angeles. We're not asking the city to promulgate regulations that lead the pack. We're asking you to follow some proven strategies that have been adopted and that have empowered cities to do something about out-of-control installations. While there has been a representative here of VICA, we can tell you that in our community, when cellular installations have been challenged, it's the businesses that have come and joined hands with the residential associations in fighting it, because they believe that these placements are hurting their property values, their businesses, their future resale value of their properties. So this is not just an issue about aesthetics from a hypothetical or an artistic point of view. This has to do with economic impacts of these installations. We need the tools to regulate, and the time is now. The city does not have the ability to challenge an installation or a person from a company at a hearing. I feel sorry for a hearing officer who looks at maps about gaps in coverage. We don't get the fees that allow us to evaluate and hire the experts in order to do this process professionally. We need those tools. We don't have a balanced playing field. Thank you.
Thank you. Edward McGaw. After Edward is Janet Turner.
Thank you, and good afternoon. My name is Edward McGaw. I'm an Assistant General Counsel with Verizon Wireless. I know the day has been long and a number of people still want to speak, so I'll try and be brief. Like my colleagues from AT&T, I think at Verizon Wireless we try and take the siting process for cellular facilities seriously. We try and work with the affected communities. Does it always work? No. But we try generally to do that. In that vein, we think that the current ordinance, the AGF, generally works, and are not sure that really any revisions are necessary. But I appreciate the dialogue that the council has had with the city attorney, the comments from the other speakers, the comments from the council members, and would strongly encourage that if the council determines that it's appropriate to move forward with a review and revision or review of the current ordinance, that it form an appropriate study group or work group to solicit input in a controlled and orderly fashion from all appropriate stakeholders. I think that's the process that led to the current ordinance. That type of process, I think, would lead most effectively to an ordinance that will serve everyone affected, the industry, the residents, the visitors, and would be most likely to result in an ordinance that people can live with and work with. Thank you for your time.
Thank you. Janet Turner. After Janet Turner is Patrick Hart.
Hi, Janet Turner, Chair of Pacific Palisades Community Council and on the board of the Western Regional Alliance of Councils, which is 13 neighborhood and community council coalition on the west side of Los Angeles. Both WRAC and PPCC unanimously passed motions calling for the city to enact a comprehensive new ordinance that regulates the aesthetics and provides protection, especially for residential neighborhoods. We strongly support the city attorney's recommendations and also ask for extended appeal rights so that community councils, neighborhood councils, and HOAs are also informed and can have a say. We also ask in the meantime, while you gentlemen are still working on this, that you put a temporary moratorium in place so that permits can't go through that we can't control later on. I would just like to say from the standpoint of a practical side from Pacific Palisades, we have found through our fights that cell phone carriers do have the ability to have leeway. that they don't have to necessarily put them where they think they have to put them. That doesn't necessarily have to be in front of somebody's house. It could be a little bit ways down near a more open area, and that they can work with us as far as the way it looks so that it matches all the street lights in the area as compared to being a sore thumb sticking up. We just need some regulation because not all of them are willing to work with us on this, and an ordinance would enable us to have that without having to fight every single time. We appreciate your help in this manner. Thank you.
Thank you. That was Jenna Turner. Patrick Hart. After Patrick Hart is Cindy Cleghorn.
Hi, my name is Patrick Hart. I am a resident of Pacific Palisades. I have a telephone pole overlooking Temescal Canyon Road, which was measured for suitability for a future AT&T T-Mobile cell phone tower site on March 29th, 2011. I'm here in support of the city attorney's report suggesting substantial regulatory reforms. However, I would like to add to the presentation that the city attorney has to be able to answer the question that Mr. Alarcon answered, is since are aesthetics the only thing that we've got to go on? And my answer to you is a definitive no. I can give you other answers, other parameters which could be put into regulatory specifications which should be known to us before a cell tower is put on. One is functionality, the second is public safety, and the third is environmental standards. And I'll use my telephone pole as the example. The telephone pole that they measured on the 29th typically runs a line voltage of 106 to 115 volts, which means that the power needed to run that cell phone tower may not be stable enough or sufficient enough to ensure a stable operating platform. I know this because I have to run voltage regulators inside my house to make my HD TV and my computer equipment stable at all times. I've had to do this for 4 years. This is a 1935 pole when this was put in. The second one, public safety. A cell phone tower adds a couple hundred pounds to the top of a tower. If you have a tower that is not in a straight line, you have a pulling factor. We get 60 mile per hour Santa Monica winds there. The cell phone tower can be pulled down by the weight of the winds on it.
You can wrap it up, sir.
And third is environmental. We have woodpeckers pecking on that pole instead of the giant sequoia, which is 40 feet away, which is 70 years old and protected. So that's all in one cell phone tower. Considerations which I would like you to take into consideration.
Thank you. Cindy Cleghorn.
Good afternoon, Councilman. My name is Cindy Cleghorn. I serve on the board in the Land Use Committee for the Sunland-Tahunga Neighborhood Council, and I'm also part of the working group for cell towers, as well as a number of other things. I wanted to talk about the support for the city attorney's report and the emphasis that there needs to be a moratorium, and also point out that we need to see the entire projects that come before us on these AGF installations. 17 inches by 20 inches is not what goes in. What goes in ends up being 30 feet by 17 feet, and it's very disruptive and a tremendous impact on our neighbors in the long run. It also has emissions later on and noise. So we need to get a handle on this and invoke the city attorney's report and update the ordinance. And thank you for your support.
Thank you very much. That concludes our public speaker cards. Are there any other questions or comments from our...
No, I think we've heard a wide range of issues and concerns, and I know the city attorney is taking copious notes, and that we will hopefully see an ordinance that reflects all our concerns. And I would just move to request that they prepare the ordinance and fold in some of the observations and questions that were raised by this committee.
Yeah. And if we direct the city attorney to prepare the ordinance, how long will that take, more or less? Do we know? Do we have an estimate?
Well, while he's coming up, the recommendations that are contained in the city attorney letter aren't really specific recommendations. They're providing a range of policy options that we really haven't discussed or weighed yet. So I'm not sure if they begin preparation of an ordinance, what exactly they would be preparing in ordinance form. And I'm wondering if it makes sense to proceed at this point with an ordinance until we've actually discussed what we want them to do.
Well, we could get a draft of the ordinance back to this committee, digest it, and then go down that road if you like.
So containing all of the recommendations that are in their letter, bring it back to this committee, and then we'll have further discussion.
Right.
I think that makes sense.
Sorry, what was that, the last point?
The suggestion that the chair made was to begin the preparation of an ordinance based on the recommendations contained in the city attorney's letter, and then bring that ordinance back to this committee so that we could discuss the various policy options that are contained in that. But at least then we will have had the benefit of ordinance language already beginning.
Okay. Yeah, and my concern was the same one that you raised, Mr. Krikorian, which is these are broad policy recommendations as outlined, and it's a very good report. And I wanted to make sure that we do have as much input both from stakeholders, community groups, organizations, and the industry as we move forward. Mr. Alarcon did point out one of possibly other unintended consequences if we move one direction. Also, I think Mr. Krikorian also pointed that out. Just want to make sure that as we move forward, we have input. And so the path that we're setting out is to get the ordinance back.
Right.
And then perhaps
have that discussion.
And
then we'll see what we can send forward.
See what we could send forward with. I'm just trying to figure out at what point do we get the input from the stakeholders and the industry.
I would like to suggest that we not do it seriatim, but rather get all of those wheels moving at the same time so that there's no further delay in the end result. If we, can start working on drafting ordinance language while at the same time organizing a working group to provide input to this committee and to the full council on impacts of the policy options, then we have both tracks going at the same time. We don't lose any time that way.
They've got to be working together, though. So we're giving direction to start drafting an ordinance and have a working group in place working with the city attorney's office to get that input. Is that the direction we're giving?
Yeah, if we, we do that, Roberto, if we have this working group, and city attorney, please advise us. And I want to welcome the Honorable Councilmember Englander to the committee as well. Mr. City Attorney, you have a body of work that you want us to review. The committee is now suggesting, based on today's dialogue, that we have a working group. Given your research and your work up to date, and Roberto, you can help us with this, can we put together a task force of a working group that provides the type of perspective we heard today, perhaps the CLA, planning department, the public works staff?
I think we need public works, CAO, CLA, perhaps DWP.
Another alternative would be for city attorney to prepare a draft document and post that document for comments from the various stakeholders and bring that to the committee for a public hearing. And the draft document that the city attorney would prepare, perhaps if you want clarity, you can ask him to consider the various issues that were discussed as far as aesthetics, as far as a fee ordinance, and
I think one of the objectives was to have it on a parallel process so it doesn't have to drag out so long. So to avoid the sequential order, if you have the draft ready that you feel should be available for comment, and that would be the point of having this task force, this task force. So I think the private sector should also be involved, different stakeholders, and the question is whom this group would be.
Well, perhaps as the city attorney has been very involved with this, they should
Do you
be.
have some insight here, Mr. City Attorney, in terms of an approach that you think you could work with?
Well, I agree that input is certainly going to be necessary here, both from the various stakeholders. But, I mean, typically on an ordinance like this, we'd also be looking for input from the council. That's why we wrote the report, to sort of tell you what some of the options were, and we've expanded upon some of them here today. But right now, we don't really have any clear direction from the policymakers as to what you want to see in the ordinance.
Well, let's do this, colleagues. What if we give them, how soon can you have a draft ready for us?
Well, it's tough without the direction, because we're not working from what, with an understanding.
We need the benefit of DWP, the input from DWP, from CLA, CAO, and the Public Works Departments, which, as a policymaker, decision maker, I don't know all the consequences of adopting this policy as written right now. So that's why I need those experts to further advise me or decision makers here. I feel we still need that additional input. This is a legally driven document that was presented to us. Now, there are other aspects to us making a decision, which is all the other issues involved that we're going to get the benefit from the departments and the industry and other stakeholders. I mean, the stakeholders, I think, they have different points of view as well as we move forward, and input that we heard today. So, how do we get an ordinance that's just not only with the legal lens, but that takes into account all these other things? And I think forming a working group that we're back in 60 days, we get something back in 60 days. But the issue is, how do we get that input? And a working group is probably the best way to go about it.
One of the approaches we can take is, and we've done this in the past, we form a task force and give the task force 60 days, and we give directive to each of the entities we feel is within the city family to respond. And then we go from there. That becomes available to the public, and then we get the public input after we've got the professional advice from all the impacted entities, and that'd be another approach. So if we're comfortable with that timeline, it gets us moving. It might not be as parallel as perhaps you were stating, but it does give us the feedback.
Well, I would suggest that since the city attorney has been very involved with this, perhaps they can head the task force, and this committee can recommend that the departments that should be involved in that task force. Councilman Weezer mentioned DWP, perhaps also the Bureau of Engineering, city attorney. As to fiscal impacts, because there was a discussion of a fee ordinance, you need the CAO. If you need CLA involvement, we can also participate.
Okay.
So it's your call as to who you want to be the head of the task force.
Well, colleagues, if you're comfortable with that, we can follow advice of the CLA, and we can just get that off the ground. That's Councilor.
With that, just a question, and I'm sorry, late to the meeting on this. I was in photo red light. Would there be a moratorium on this in the meantime? I didn't follow the discussion.
No. That has not been discussed. That has not been decided by the committee. No. The issues, I think, for clarity for the city attorney, perhaps it would be good to go over the issues that were discussed and ask him to incorporate those issues into an ordinance. And I think I was taking notes. One of the issues was aesthetics. The issue of aesthetics, the issue of notification that you brought up, Councilman. I think following the conditional use process, a 500-foot notification. The issue of the fee ordinance as far as enforcement and who would be involved will be the Bureau of Street Services. That's perhaps another agency that should be involved. The issue of exempting, I think it was utility poles, you need DWP involved. As an issue as far as a permit timeline.
Okay.
That needs to be
Why don't we phrase it this way? Why don't we just delineate each department and leave the phrase other departments as needed?
Okay.
To make sure we're inclusive to all the different issues that were described.
Sure.
And to bring up Councilmember Englander's suggestion or observation, or question them. Do we impose a moratorium? Do we have that capacity to do that?
I think you do, but that would be through, I think you would need to enact an ICO, an inland control ordinance, to do that, and perhaps the city attorney can rely on that. Right, but germane to the discussion.
We're talking about the motion.
Moratorium.
That could be a follow-up action. Okay, since it's not been agendized, so.
Yes, Ken Fong, Deputy City Attorney here. Our work with Ted, I represent planning and he represents public works, and it seems to me that there's a complicated mix here, and it may not be possible to have a moratorium that fixes it in the way that you think it might. But, we'll discuss that, and if it's possible, you can consider that.
Give us some advice once you review that recommendation.
Yes.
Yeah,
okay.
I'll work with Ken on that. Just for full disclosure, my understanding is the current AGF ordinance, prior to its adoption, there was a moratorium. That's just part of the factual background, and we've received some information from some of the community that's right here behind me, that there other cities have done moratoriums as well, and there's been some language in the PUC about that. But I'll have to work with Ken on that.
Please, and can you come back next week to give us some insight, and perhaps in the meantime we can have a directive come from both committees to form this task force?
Sure, and now you have a quorum of public works, so it will be a joint.
We're going to have a joint meeting next week.
Clarification, you're going to bring back the ICO at that point to see if it's feasible or
They're
legal?
going to give us that advice.
It's going to be, it's going to be an offline discussion, and I think we can't do it today because it wasn't agendized.
So are you asking for a joint meeting next week?
Yes, if
Again?
that's
Yeah,
convenient.
I will be out of the office next week on vacation.
What?
Right. Every once in a while they let us go. And by the way, there's no cell
You have a
phone signal where I'm
backup? You have no one on deck? So you can't meet next week?
I'm going to be in an area that actually has no cell phone signal.
Okay.
Yeah.
So we'll have to wait 2
In the
weeks?
mountains.
2 weeks, joint meeting?
Oh, shoot. 2 weeks of signs. We're doing this, in 2 weeks we'll do the sign ordinance. This will be very hairy.
Yeah. Oh, we're going to work on the schedule, yeah.
But in the meantime, let's get the directive off the ground and form this task force.
And you want the city attorney to be the head of the task force?
Yes.
Okay, and then we'll work with the clerk as far as the departments that should be involved?
Right.
Okay.
Okay?
And the goal is to be back in 60 days.
The goal is to be back in 60 days.
An ordinance, yeah.
All right.
And as far as the further directives, Councilman, there was an issue of definition. I think Councilman Alarcon mentioned definitions as far as significant gap. Maybe that's something that can be folded into the ordinance.
If we're going to include the term significant gap in the ordinance, I can assure you that we'll define that in some way.
Okay.
Or at least we'll indicate the factors that go towards that analysis.
And also there was an issue of cumulative impacts. I think as far as the CEQA clearance, I don't know if that's something that should be folded in as well.
Just put everything in there so we can have as complete possible.
I'm just mentioning it on the record so that the clerk can, when he writes the report, it's part of the record.
No, I feel you.
Okay.
Okay. Mr. Clerk, everything's okay? All right. Okay, so that'll be our directive, and we'll get that off the ground.
Okay. I have to listen to the tape now to catch all that.
Okay. If not, you know where to find us. All right, so that concludes that item, and both committees are adjourned at this time as far as the joint committee. We still have one more item left on Plum,
Public Works is all done.
and that's item number 1.
Yes, sir, and that's Motion Parks Rosenthal, and it's asking planning and DOT along with SCAG to report, to prepare a report relative to the impacts of the 2012 Regional Transportation Plan and Sustainable Community Strategy on those alternatives.
Okay. Can we have the SCAG staff come on up? And I want to thank you for your patience. Appreciate your support.
Thank you, Mr. Chair, committee members. I'm Rich Macias, Director of...
Excuse me, sorry. Councilman, City Attorney has advised me that as far as the joint meeting, it would be appropriate to ask for public comments as far as the joint meeting was concerned.
Okay, so just hold on for a second. Want to go ahead and ask?
Is there any general public comment on items not listed on the agenda for the Joint Public Works and Plum Committee? There's none. Meeting adjourned.
Great.
Okay.
Formality is completed. Sir.
Mr. Chair, committee members, Rich Macias, Director of Transportation Planning, Southern California Association of Governments. We're here today to give you a status on our current efforts in relation to the development of our Regional Transportation Plan, the RTP, which is the principal reason why SCAG exists. We produce the RTP every 4 years. What is different about this RTP is that the passage of SB 32 and SB 375 now causes us to address a state mandate, an unfunded state mandate, I might add, by which we now have to review, assess, and determine how, through the course of the development of the Regional Transportation Plan, we will reduce greenhouse gas emissions, given the standards that were developed by ARB. Those standards are such that by 2020, on a per capita basis, we need to reduce greenhouse gas emissions by 8% region-wide, as well as by 2035, 13% region-wide, again on a per capita basis. To do that, we need to develop the nexuses between land use, planning, and transportation infrastructure investments. That process will realize the economies of scales, not only in terms of reducing emissions, but providing better quality of life, better mobility, and in some cases, given the instruments for mobility, development of additional revenues to pay for transportation investments. To that end, we are in the throes of developing our draft RTP, Regional Sustainable, SCS, which is our Sustainable Community Strategy, which is mandated by SB 375. Currently, our schedule is such that we will produce a draft RTP SCS by November of this year. We will put it out on public review, and we will ask our board to approve a final RTP SCS upon conclusion of public review in April of next year. Consequently, we will then submit our final documents to the federal agencies, who will then, in consultation with EPA, make a determination of air quality conformity. All this we have to do to ensure that all federal transportation dollars in the region are fluid. Important date to remember, August 16th, we will have a public workshop for the general public and all our stakeholders at the SCAG offices here in Los Angeles, in which we will discuss and review the scenarios that were developed. There are currently 4 scenarios that were developed. These are high-level scenarios. I want to emphasize that we are not, SCAG is not in the scenario analysis mode, but rather we're in a scenario development mode. These are high-level scenarios that simply offer our stakeholders and the public a menu of options that could ultimately be utilized in the final set of alternatives, which will be included in the Regional Transportation Plan come November. So these are high-level alternatives. They've not been subject to the SCAG Regional Transportation Model, so we have no numbers. We've not implemented our EIR work. Our plan and our goal is to obtain as much public input as we can prior to developing the final set of scenarios that will then go out for public review yet again through the formal documentation.
Good. I want to thank my colleagues for the motion that brought this to the committee. At that time I was out of town, but I'm glad my colleagues are moving on this issue. It's very important. The timing is significant. From a regional point of view, There's also the concern for equity, fair share, in terms of how these policies impact different areas within Southern California. And so I know I'm seeking the type of advice and insight from the departments that gives us the ability to respond to your scenarios. So I hear what you're saying. It's not the analysis that you're performing, it's scenarios, but the mere fact that you are creating the scenarios creates a stage. You're setting the stage for a certain type of dialogue that can have different levels of impact in different areas. And that to me is what is of concern. And so I look forward to this work with you. And I see Ms. Patsoros, thank you for joining us. We do have staff here. Would you like to come on up, staff, and just address the issues as described? And Ms. Macias, thank you for that articulation. And August 16th is the big one, huh? Okay. Come on up, both of you, come on up. We're a team here. Come on up. Okay.
Afternoon, Naomi Guth with the Department of City Planning. We have been following the development of the RTP and SCS along with the Department of Transportation, attending various monthly meetings. And at this stage, the Department of City Planning is starting to look at the various components of the scenarios that SCAG is crafting and looking to see specifically what kinds of projects and policies that are part of the planning department's work that we think need to be part of the different scenarios. They have sort of a existing conditions kind of scenario, and then they build on the intensity of different kinds of investments that are land use and transportation related. And we plan on working jointly with the Department of Transportation, which Mitchell will speak to here, regarding the domain of their work. For example, our department was the lead on developing an update to the city's bicycle plan. There is an implementation program, and we want to see that gets incorporated. Much of that implementation is done by DOT. So our departments look forward to working together on this framework of currently 4 different scenarios that SCAG has crafted, giving input perhaps to all or maybe only one of city interests and priorities.
So you mentioned the bicycle plan, but the focal point will be the land use developments that are being portrayed by the SCAG through their scenarios, correct?
That's correct. The land use scenarios that show where the growth forecast over the next 20 to 30 years, where we see increases in density, where the areas of the city that can accommodate the growth.
Right. Miles, come on up. And I'd like to hear your perspective and your role.
Okay. Yes. Good afternoon, Mr. Chair, members of the committee. I'm Miles Mitchell with LADOT, wearing sort of 2 hats. I represent LA Department of Transportation, and I'm also the sub-regional coordinator for Los Angeles to SCAG, and have been in that
So what does that
role for
mean?
about 12 years. The sub-regional coordinator represents Los Angeles on an administrative level to SCAG, coordinating communications from SCAG to the city and from the city back to SCAG, and also managing the grants application process, where when SCAG has money, which they haven't had for a few years, I coordinate the submittal of grant applications to SCAG for funding consultant studies.
I see.
So essentially, that's the coordinator's role. Well, with that experience as sub-regional coordinator, I just want to emphasize that I'm very grateful that Council passed the resolution on July 8th asking SCAG to provide input to the city on the impact on the city of the different alternatives. We have not yet, to my knowledge anyway, received that input from SCAG that actually was due last Friday, July 22nd. I'm also grateful that this motion that is before us here this afternoon was introduced to Council, requesting that the 2 departments provide input to Plum and to Transportation Committee. I'm hopeful that the Council will adopt the motion asking that both departments, DOT and Planning, prepare written reports evaluating both transportation and land use scenarios so that we can provide input to SCAG indicating the city's preferred alternative by approximately mid-September. It's a fast timeline here. As Rich Macias mentioned, the draft will be released in early November, so we have about 3 months, and we need to get really busy here. So I'm grateful that this process is going forward.
So, Miles, when I understand from Mr. Macias that August 16th is a date in which certain scenarios will be portrayed, will those scenarios that we will be viewing and or analyzing in the future, does that come with input from the city departments and city family?
Well, the scenarios before us now that SCAG is using in their workshops that they've entitled the rapid fire scenarios really don't have a lot of city input. As Rich mentioned, they're high level sort of macro scenarios. The workshop on August 16th, as I understand it, will involve a refinement of those scenarios. So really, SCAG has not yet received significant input from the city, and that's what we need to make sure we provide.
But given all this energy up to now, we should be prepared.
We should be as proactive as we can be. Okay. It's my experience that once the draft RTP and now the SCS is released in early November, although theoretically it's possible to change, it has at that point a lot of momentum, and so we need to get our input in mid-September.
Okay, thank you. Any questions or observations from my colleagues on this? Okay, so we will refer to the planning and transportation departments and request that a written report.
Councilman, I think we're going to alter that recommendation.
Okay, go for it.
We're going to adopt the motion. We are going to instruct planning and DOT to write a written joint report.
Okay.
And I believe that the deadline has been changed by the suggestion of the planning department, and that report should be done within 30 days. And we're also going to be specific as far as planning and DOT evaluating the alternatives, and planning, obviously, as the experts, should look at land use, and DOT at transportation.
Thank you. Thank you. Okay, so seeing no other questions, thank you very much. And again, thank you for being here and your patience as well. Appreciate that very much. Okay, so anybody here for public comment on items not on the agenda? Seeing none, this meeting is adjourned.
There's one guy sitting over there. Do you have a public comment?